To me, it's repugnant, and it's not something that should happen today in this country.
Okay. All right. Thank you.
Yes. I want to test your knowledge of some of the Supreme Court decisions. My first question is, what do you understand to be the basic structure doctrine? Is it applicable in Kenya? If so, why? If not, why?
Basic structure doctrine is applicable in Kenya, and it's applicable. There was a Supreme Court decision, I think the case of BBI, where Supreme Court held that the basic structure doctrine is applicable in Kenya, and gave instances when the constitution can be changed through universal suffrage, or through parliamentary process, or through personal initiative.
Okay. Just explain to me the last bit. Through personal initiative, how?
Through either through parliamentary process, or even by the president making a proposal for the change of the constitution, or maybe a group of people wanting to have the constitution changed.
Okay. Yeah. Thank you very much.
It's me. Yes. Okay, thank you, my lady. Good afternoon once again, Wakili.
Good afternoon, my lady.
Now, we are trying to test your judge readiness, should you be successful in your bid to become a judge of the High Court. I want you to walk us through the steps in a criminal trial from A to Z, and what you consider in those steps.
Thank you, Commissioner. A criminal trial begins with plea taking. After the person has been charged and brought to court, the accused person takes a plea. The charge is read to the accused person, who either pleads guilty or not guilty. From there, two scenarios happens. When the accused person then pleads guilty to the charge, I'll take you through that first. The judicial officer calls upon the prosecution to read again the facts of the case to the accused person in the language that he or she understands.
Did you say when he pleads guilty?
When he pleads guilty.
Okay.
The charge, the facts of the charge are read to the accused person again, and the accused will be called upon to confirm or deny the veracity of the facts. If the accused person says the facts are correct, then a plea of not guilty, a plea of guilty is recorded. If he accepts, if he pleads guilty to the charge and the facts, plea of guilty is entered, and the accused will be called upon to mitigate. After the mitigation, maybe the prosecution might also want to present any aggravating factors, and the person is then convicted, and a sentence will be passed, either a fine or a suspended sentence, or a community service order, or be placed on probation.
My friends are waiting to engage you, so we may need
Yes.
to rush it a bit, yes.
So that is when the accused person pleads guilty. If the accused person pleads not guilty, then a plea of not guilty is entered. The judicial officer goes ahead to make a decision on the bail and bond and fix the case for hearing. Once the hearing takes place, the prosecution will present their case, the witnesses, their evidence, but before that, the accused is provided with all the witness statements and documents that the prosecution might wish to rely on. Once the prosecution has presented its witnesses and documents, and they close their case after the cross-examination by the accused counsel, the prosecution closes its case, the judicial officer will make a decision whether the accused has a case to answer or not. If the accused has no case to answer, and the defense maybe makes a submission on that, and if the judicial officer finds that the accused has no case to answer, he or she will be acquitted under section 210 of the CPC. If the judicial officer finds that the accused has a case to answer, the accused will be put on his defense or her defense. They will also be called upon to call their witnesses and present their case. The prosecution will have the opportunity to cross-examine.
If I may interject a bit, at the point where the accused has been put on his defense, there's a step there you are missing. What happens before the accused gives their defense?
There will be submissions.
After submissions, the accused has been put on his defense, isn't it?
Yes.
Now, before the accused gives his defense and calls his witnesses, there's a critical step there you are missing.
The accused will be told to elect whether to testify by way of sworn statement or unsworn statement, or even have the opportunity to be silent.
Okay, now you can go on. So the prosecution has, the accused has called his witnesses and closed his case.
Once the defense has closed its case, both sides will make a submission, and after the submissions, the judicial officer will retreat to writing her or his judgment. And if the judicial officer finds that the prosecution has proved its case beyond reasonable doubt in a criminal trial, then the accused will be convicted, either sentenced to non-custodial sentence or custodial sentence, or a suspended sentence, or a community service order, or on probation.
The array of sentences.
Array of sentences. And
Okay.
if he is found not guilty, will be acquitted under section 215 of the CPC.
Okay. Now, this court that you seek to join has a huge problem of backlog. Can you tell us, in the 2024-2025 SOJA report, what was the case clearance rate for the High Court?
Overall, I think I think 60%.
Case clearance rate?
The High Court.
Have you seen the SOJA report?
Yes, I did. I've seen
Yes.
it. I've read it. Only that I can't remember the figure. But there is a backlog in the High Court.
Okay. The case clearance rate is 117% for the High Court.
That is okay.
Okay. So now can you share with us briefly the innovative ways with which you can contribute in case clearance as well as backlog reduction in the High Court?
I would, in my court, that is, I would speak for myself, I would categorize the cases. Because if maybe I'll be in a criminal division or in civil division or commercial division. Or
Imagine you are handling all.
If I'm handling all, I will categorize the cases into three. One category of small claims, those with value of less than 1 million shillings. Fast track cases where the facts uncontested, and those cases where the facts are contested. For the cases where it's not contested, I would list them for hearing on a Saturday. And I think I'm not reinventing
On a Saturday?
the wheel. Yes, because the Chief Justice is piloting in Kibera Court. For the uncontested cases, I will reserve them for Saturday and I'll clear them on Saturday. For the small claims, of course, they'll go to the small claims court. For the contested, I will hold a pre-trial conference, give pre-trial directions, narrow down the issues, bring on board the court users, bar bench, ensure that I give clear directions on how those contested cases will proceed. I will be also a screening officer as a judge. I will screen all my cases, all the files that come before me, I will screen them and see those cases which are ripe for ADR and AJS. I will divert them under section 159(2)(c), section 59(b) and 59(c) of the Criminal Procedure Act, Civil Procedure Act, under the Civil Procedure Court Annex Mediation Rules 2022 and section 5 of the rules.
Okay, you'll explore ADR, in short.
I will explore that. I will do it for every case except sexual offenses.
Okay.
And I will not wait for any party to raise it. I will raise it myself as a judge because of the backlog.
Okay. Okay, thank you, and I wish you well. Thank you, my lady.
Just one thing. Now, Mr. Abdi, you have proposed that in a bid to clear backlog in the High Court, you look forward into sitting on a Saturday so that you clear those matters which you as fast as it possible. That's a good initiative. But the scheme of things in Kenya now is that courts sit on weekdays, Monday to Friday. Do you think you need the permission of the Honorable Chief Justice for you to be able to sit on Saturday, or you can just do it somewhat on your own?
Well, the Chief Justice has pronounced herself on that about a week ago, and the Saturday sittings is being piloted in Kibera Court. However, I would still do the same in consultation with my principal judge, and only if the scheme of things, as you have rightly said, allows, I will not do anything illegal. But in an effort to clear backlog in my court, I wouldn't hesitate to sit on a Saturday if the law allows.
So I'm coming back to Ahmed, that issue. Do you think, in your own, do you think you need the permission of the Honorable Chief Justice to be able to sit on a Saturday?
Through the principal judge, yes, I do.
Okay, thank you.
Thank you, Honorable Chair, and welcome again, Mr. Abdi. Now, one or two questions from me. How will you apply the principles and objectives of Leadership and Integrity Act in your work as a judge, as a High Court judge? First of all, what are those principles?
The principles of leadership and integrity is impartiality, integrity, accountability, transparency, efficiency.
Okay. Go ahead and say how you'll apply them.
I would ensure that my decisions are not influenced by external forces. I will be impartial. I will ensure that there is no corruption in my court. I will declare under the Leadership and Integrity Act my assets, my liabilities, and I will uphold the constitutional principles.
Okay, very well. Now, I have some feedback here from the public and the stakeholders, but I would want to hear from you what you think, or what do you think the stakeholders or even the public, how do they describe you?
How the public describes me? Well, I don't know how the public describes me, but
What do you think people say about you?
they say I'm firm. They say I'm firm. I'm not corruptible. I'm uncorruptible. Firm, focused, and they say he sets his goals. He's not easily swayed, and believes in what he does and what he says.
Okay. Yeah. That is very true. There are no integrity issues that were raised against you. They also, of course, say you are of good temperament. You are calm to all the people who interact with you, which is good. But however, how long did you work with the NLC? Or are you still there?
No, I'm not there. I worked only for a year.
Okay, because there are some stakeholders who say that you were unreliable when you were at NLC. What do you say about that?
When I was?
At NLC.
Well, when I joined NLC, when it was first started under the 2010 Constitution, I didn't work for long. I worked only for 1 year.
Okay.
I was initially posted here at Nairobi, then to Nyeri, and I left NLC through mutual consent between me and the employer, National Land Commission, because I told them I will not work in Nyeri.
Okay. So you resigned?
Yes.
Okay.
Yes.
You
By consent.
You had a problem working in Nyeri?
Well, it was at the beginning when there were a lot of hiccups. There were no facilities. There was no office. And I was told to go and hang around the county commissioner's office. And I didn't find it productive for me to just go and hang around there and earn salary. And I told them I would rather leave. Yeah. They just wanted me to earn salary and just stay there. But I said, no, I wanted to work. Yeah, and there was nothing because
So
they were still putting their structures together. Okay. So there was nothing. But they just wanted me to be on the payroll. But I said, just keep the money, put it into use elsewhere.
Okay. Yeah. Thank you. I wish you all the best.
Thank you, Honorable CJ. Before I ask my question, just a write down what Commissioner Kisotu was asking. Resources in the judiciary are very lean. We operate almost, we are very stretched when it comes to resources. And I don't know what you're going to do if you're successful and you're posted in a station that you have to make do with what is available to serve Kenyans. Are you also going to leave?
Oh, no, I'm not going to leave. And I mean, I'm not interested in those resources. I mean, whatever I get will be enough. Again, the judiciary and that incident probably of the National Land Commission is not the same. Judiciary is well established. The resources, of course, are strained everywhere, not only in the judiciary. But But I'll be happy to work anywhere with the little resources. I am 57 now, and I think I don't need extravagancy. With the little that is there, I would discharge my duties, even
Okay.
under a tree. Even under a tree.
All
I don't
right.
mind. Even mobile. If I can be able to reach the farthest corner of this country, I won't mind.
Fair enough. What would you say is your greatest motivation to apply for this role? What is really pushing you?
Well, I really want to we all look, we all have ambitions. I've come from very far, as I've told you. And I had set my eyes on the ball a long time ago. I'm still in the journey. And I think once I land in the High Court, I would be comfortable to discharge my duties and say I have reached the pinnacle of my career.
Okay. Please describe yourself as a leader. What is your leadership style and how would you describe yourself?
Well, I'm very caring. I work, I like working collegial. I like listening. I like consultation. I respect everybody, whether you're junior to me or you're senior to me, whether you're rich or whether you're poor. I don't differentiate. Power doesn't shake me. I have seen it. And money doesn't also worry me. I've lived without money, and now I have money. So I respect everybody, and I expect also respect.
Okay. In your various roles as a leader, have you encountered the younger generation in the workplace, the Gen Zs and the millennials? And if so, what has been your experience with this group?
They need mentoring. The young generation, they need to be mentored. Of course, they are in a different times from ours. They want to get it very quickly. They don't observe time. They rush to judgment. And therefore, they are a very difficult lot. But they need to be mentored.
Okay. So you encounter with the ones you've encountered, you find them very difficult to deal with? Because that's the biggest population in the judiciary.
It's not difficult, but we need to nurture them. We need to tell them why it is 8 to 5 or 9 to 5, why you must clear your desk, why you must do what you have to do, why you have to be patient, why you have to work hard, why you have to appreciate what you have and look for what you don't have. They constitute a large population, a segment of our population, yes, but we are different. Our time and their time, when they are growing up and when we grew up, our times are different. They have everything, technology on their fingertips. Education is almost free. They can access, but they are not patient.
Okay. I will take that. Thank you and I wish you well.
Thank you, Commissioner.
I think it's afternoon now. Good afternoon.
Good afternoon,
Yes.
Vice Chair.
Can you relax ama umechoka?
Niko sawa.
Uko sawa.
Niko sawa.
Who are the key stakeholders in the justice sector? And how would you effectively engage with key stakeholders in that sector?
Key stakeholders, the National Council on Administrative Justice, the ODPP, the public, LSK, Parliament, the executive. These are all very important stakeholders.
How would you effectively engage with these ones, with them?
I would engage with them, some of them, like the Law Society of Kenya, through the Court Users Committee, through the Bar Bench Committee, the prisons, the police, all through the Bar Bench Committee. The judiciary is already engaging with the Parliament and the executive through the soldier report, which is a statutory requirement every year, like we had last year, through the National Council or Administrative Justice, where all these stakeholders sit. The judiciary engages with them. But for me as a judge, then the channel through which I can engage is through the Court Users Committee and the Bar Bench Committee.
How would you handle criticisms from the public or media regarding your decisions?
I will take it in my stride. I wouldn't overreact. I will take it positive. If I'm wrong, I admit I'm wrong. I correct myself. If I'm right, I believe I'm right, I will stand firm. But I will not react to it, especially the media and the social media and the mainstream media. I would stay away from it.
Thank you.
Yes, this is almost coming to an end, Mr. Abdi. Just the last one on the area of general practice. I want to know from you the meaning of a decision of a court that is made per incuriam.
I can attempt per incuriam is a decision that is made in a bench of 2 or 3, without any dissenting voice.
Okay, I think I will not belabor that. I will just ask you to go and refresh yourself.
Thank you, Madam.
On what is a judgment made by incuriam. But thank you very much. And on behalf of the Commission, wish you well. But before we release you, we always give the candidate an opportunity also to engage with us.
Thank you, my Lady Chief Justice and the Commissioners. I want to thank the Commission for having given me this opportunity to appear before you. I don't take it for granted. There were many applicants, but I got this opportunity. I have stated my case, and I leave the rest to God and to this Commission. And I want to thank you all and wish you the best.
Very, very well. We also thank you. And we'll get in touch with you when we complete the exercise. It's a very competitive exercise, but we wish you well and encourage you to continue doing the good work that you're doing to serve Kenyans in the various positions that you occupy.
Thank you, my lady.
Yes, have a nice afternoon. You can carry your writing pad and your water.
Thank you, my lady.